Has your health insurance claim been rejected? Or have you suffered due to a doctor's mistake? You are not alone, and you're not helpless. In this video, Consumer Times breaks down exactly what medical negligence is, how insurance companies wrongfully reject claims, and what you can do to fight back. Watch till the end, there's a step most people miss that can completely change the outcome of your case. Drop your questions in the comments, we read every one. Subscribe to Consumer Times for weekly guides on your rights as a consumer. Namaskar, and imagine this: you or someone in your family goes to a hospital, trusts the doctor completely, and something goes terribly wrong. Or perhaps you have been paying health insurance premiums faithfully for years, and the moment you file a claim, it gets rejected with a cold, one-line letter. Both of these situations are far more common than most people realize. And both have one thing in common: the victims almost never know what rights they have or what steps they can take. Welcome to Consumer Times. I am your host Dr. Arun Kumar. Today we are covering two of the most devastating things that can happen to any patient or policyholder: medical negligence and insurance claim rejection. By the end of this video, you will know exactly where you stand and what you can do about it. Let us begin with medical negligence. Medical negligence occurs when a doctor, hospital, nurse, or any healthcare provider fails to deliver the accepted standard of care, and that failure causes direct harm to the patient. It is important to understand that negligence is not simply a bad outcome. Medicine is uncertain, and not every unfavorable result is negligence. What the law looks for is a failure of duty, a gap between what a reasonably competent medical professional would have done and what was actually done. Common examples include a wrong diagnosis that led to incorrect treatment, a surgical error that could have been avoided, prescribing the wrong medication or dosage, performing a procedure without the patient's informed consent, or negligence during childbirth that causes injury to the mother or the newborn. In India, victims of medical negligence can seek remedy under the Consumer Protection Act of 2019, which treats patients as consumers of healthcare services. Cases can also be pursued under the Indian Penal Code if the negligence is criminal in nature. You can file a complaint before the District Consumer Disputes Redressal Commission, approach the State Medical Council to have the doctor's license reviewed, or initiate civil or criminal proceedings in court. The choice of forum depends on what outcome you are seeking, whether it is compensation, professional accountability, or both. Proving medical negligence, however, requires meeting a legal standard. You must establish four things clearly. First, the medical professional owed you a duty of care, which is generally established by the existence of a doctor-patient relationship. Second, they breached that duty by acting below the accepted standard of practice. Third, that breach directly caused your injury or worsening condition. Fourth, you suffered actual, measurable damage as a result, whether physical, financial, or both. The strongest evidence you can gather includes your complete medical records, prescriptions, diagnostic reports, the discharge summary, any correspondence with the hospital, and most importantly, an independent expert medical opinion that clearly states the standard of care was not met. One critical warning: never sign any document presented to you by the hospital under pressure following an adverse medical event. Hospitals sometimes ask families to sign papers that could be used against them later. Get everything in writing and keep copies of every document from the day of admission. Now let us move to insurance claim rejections, which is another area where millions of policyholders suffer silently every year. Insurance companies reject claims for a range of reasons. The most cited ones include non-disclosure or under-disclosure of pre-existing conditions at the time of buying the policy, treatment falling under specific exclusions mentioned in the fine print of the policy document, failure to intimate the insurer within the prescribed time window, treatment taken at a hospital outside the approved network, or a claim filed before the applicable waiting period has lapsed. While some of these rejections may be technically valid, a large number are unfair, arbitrary, or based on unreasonable interpretations of the policy terms. Under the Consumer Protection Act of 2019, any such unfair rejection constitutes a deficiency in service, and you have every right to challenge it legally. If your claim has been rejected, here's what you should do step by step. Start by reading the rejection letter carefully. Every rejection must state a specific reason, and the insurer is legally obligated to provide this. Then gather your full set of documents: the original policy, the claim form, all hospital bills and records, the discharge summary, and the rejection letter itself. Your first move is to file a formal grievance with the insurance company's internal grievance redressal cell. They are required by IRDAI regulations to respond within 15 days. If the response is unsatisfactory or there is no response at all, your next step is to approach the insurance ombudsman. This is a free, quasi-judicial authority set up specifically to resolve disputes between policyholders and insurers without the need for lawyers or court fees. The Ombudsman can adjudicate claims up to 30 lakh rupees and is required to resolve complaints within 30 days. If the Ombudsman's decision does not satisfy you, or if the claim amount exceeds their jurisdiction, you can escalate to the Consumer Forum. Keep in mind that you have 3 years from the date of claim rejection to file your legal case, so do not delay unnecessarily. Sometimes a person faces both situations simultaneously. They suffer due to medical negligence and their insurance company then rejects the claim for the resulting treatment. This is a devastating double blow, but it also gives you 2 parallel legal avenues to pursue at the same time. You can file a complaint against the hospital or doctor for negligence and simultaneously challenge the insurance rejection before the Ombudsman or Consumer Forum. Courts have consistently held that when both failures occur together, the victim is entitled to comprehensive relief. In such situations, maintaining a detailed written record of everything, dates, names, conversations, decisions made by the hospital, and communications with the insurer, becomes absolutely critical. If possible, get a second medical opinion immediately after an adverse medical event, before the evidence becomes harder to gather. The law exists to protect you. Medical negligence and insurance claim rejection are serious violations of your rights as both a patient and a consumer. The process may seem intimidating, but you do not have to face it alone. Document everything from day one, act quickly within limitation periods, and use the free remedies available to you before spending money on litigation. If you found this video helpful, please share it with someone who might need it right now. Like and subscribe to Consumer Times for more content that puts the power back in your hands. And if you have a personal experience or a question, drop it in the comments. We read every single one.